Okay, let's go on the record on cause number DC 1815106, Versailles Dallas versus Zatoon. Council, make your appearances.
Tyler Smith on behalf of plaintiff Versailles Dallas, Inc.
Good morning, Your Honor. It's Jonathan Scott on behalf of Jordan and Erin Zatoon.
And Joe Ackles on behalf of Jordan Zatoon.
And Ms. Arledge, who do you represent?
Apologies, Judge. I think I came in a little early. I'm here for a 10:15.
Okay.
I'll come back.
That's okay. You can wait here if you'd like.
Thank you.
All right, let's go ahead and get going on this one.
Sure. Good morning, Your Honor. Jonathan Scott for the Zatoons. This is our emergency motion to vacate an order that was entered in February 26, 2019, granting a partial default judgment to Versailles Dallas. This was a motion that was mooted on the same day that they filed it. I appeared as counsel at that time. They never set the motion for hearing. They never gave me any notice that they were proceeding with it. And we found out about it, Your Honor, in the August 7th, 2020 mandamus petition that they filed against Your Honor, in which one of the arguments is that the procedural history of this case is that everything that we were doing in 2020, the Versailles case had already been litigated and won on a default judgment, and therefore the Court of Appeals, according to them, should grant a mandamus on your May 11th, 2020 and July 24th, 2020 orders granting discovery, because they're claiming that they didn't have an active case pending against our clients. And it's all there as a matter of record. The motion for a default judgment was filed at 3:46 or 3:48 p.m. on December 21st, 2018. At 4:24 p.m., we filed an answer and appearance and counterclaims against them, and yet they never advised the court that their motion was rendered moot and withdrew it. And we've cited, and I'm sure Your Honor is aware of it, Texas Supreme Court authority that says that if a motion for a default judgment on a failure to answer is made and the defendant answers, even if the answer is late, that moots the motion for a default judgment, and any default judgment that's thereafter entered would be inadvertent and void. And so what's going on here, Your Honor, is revisionist history, two different recitations of and conduct on the part of Versailles and the El Chamis. So in this court, of course, it wasn't very long ago, you'll remember that we were arguing motions for summary judgment on July 24th, 2020. And nothing was ever said about that Versailles' case was over and that the only issue remaining was an assessment of attorney's fees. And prior to that, so after this default judgment, which, Your Honor, we knew nothing about. My client never received notice from the clerk of the court. There was no mailing to their last known address that's noted. And I was not even aware of it until I see it raised in their mandamus petition for the very first time, and never raised in front of Your Honor at any point in the pleadings. And here you have a situation, Judge, in which we're not merely talking about that they were silent on the issue. They filed two subsequent petitions in this case. So this is a default order that they're trying to take advantage of in the mandamus, saying the case is over, and therefore, Judge, you ordering that we get relevant discovery, that it was irrelevant, and therefore you abused your discretion, according to them. But in your court, Judge, they filed on February 20th, 2020, so about a year later, a first amended petition asserting claims on this same debt, this same promissory note, and seeking a judgment. Then when Mr. Suster and Mr. Smith appeared, June 30th, they filed a second amended petition, again asking for affirmative relief on these same debt claims. And yet in the Court of Appeals—
Mr. Scott, I get it. So let me hear the response.
Yes, I mean, Your Honor, it is what it is. The court's record reflects what it reflects. And I would note we came into this case in about April, and we're trying to represent a client. I'm a little confused how this thing's been sitting out there for about a year and a half, and no one's done anything. And really, they at those MSJ hearings that they speak of, they're arguing about this motion for default. And so I'm not sure how they were unaware that a motion for default had been filed or a judgment entered. That confuses me. But in any event, there was a judgment out there. We discovered it. We have a duty to represent our client, and
let me make sure I understand. It's an interlocutory judgment, right?
Correct. It's an interlocutory default judgment.
I'm going to go ahead and vacate that then. Anything else, guys?
Well, Your Honor, they've proposed an order that has findings that are, the court can't be making findings. I'm not really sure what they're trying to do there, but I mean, the court can vacate this judgment, and we.
So I have a copy. I have a copy if you want to. There does seem to be some issues with the order. It says it is ordered that the motion is granted in the court's partial summary judgment. It should be partial default judgment, right? Not summary judgment.
I apologize. I'll amend that, Your Honor. I'll correct.
I'll just change it.
And Your Honor, we would also request that all these findings they're trying to have the court make. I mean, those are not proper. Findings are made after a judgment in a trial, in a bench trial. They can't be having the court make findings on these things.
Why would I make findings on these?
Your Honor, in ordinary circumstances, we wouldn't be asking for that, except that I think that it would be helpful for the Court of Appeals to understand that this case has been litigated on the merits for the last 2 years. And so the issue.
Couldn't they just see that in the record?
Yeah.
Yes.
We would ask the court to strike those findings, and if the court's inclined to vacate the order, that's fine. And we just would request none of these findings are made.
I'm going to keep. Was it inadvertently entered? Is that the deal? I'm trying to. What I would guess happened is that if you filed them on the same day, that we wouldn't have. It depends on. We might have signed it without realizing that you had signed. I guess that is inadvertent. Okay, so I'll keep finding number 2. I think the rest is pretty clear. Okay, so I'm going to keep finding number 2. All right, anything else, guys?
No, Your Honor. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
All right. Let me just make sure there's no other issues. Okay. All right, sounds good.
All right.
Thank you.
You guys be safe
Thank you.
out there.
You too. Thank you, Judge.
You too. Take care.
All right, bye-bye. Miss and Sheriff, just so you know, we have a wedding that's going to be coming in at 10:30, and then there's going to be an actual trial in here at 11. So you just got to know what's going on. Okay. So, all right. So is everyone here on the Pratt case? And Mr. Honeycutt, you can head out now. They obviously aren't showing up, so no worries.
Thank you, Judge. Have a good day.
All right, thank you. I don't know what's going on out there. Huh? What's going on out there? All right, Miss Arledge, what are you here for? And James, what are you here for?
Good morning, Judge. I'm here on the Harris versus SB premium case. It's DC 19-00359.
Okay. And then James, I don't know, are you James Harris maybe? So you're muted.
Apologize, Judge.
Are you Mr.
Yes, sir.
Harris?
I'm James Harris, representing Kenneth and Jody Pratt versus Dallas Central Appraisal District.
Okay, just so you know, in the future, when you're doing these kind of hearings, it's helpful to just put your full name there. That's probably something you probably use Zoom, for your personal life, which is no problem. But it's easier for us when we have a lot of hearings like we do now. to kind of know what's going on. So who you
That's no
are.
problem. I apologize for that.
That's okay. Just a suggestion. All right, Miss Melly, are you here on the Harris versus SB premium case as well?
Yes. How are you, Your Honor?
Good. How are you?
Great.
Hello, Miss Cox. What are you here for? Miss Cox, what are you here for?
Hearings on motions for continuance
On which case?
for Kenneth Pratt, cause number 19-14747. and Eagle Rock 19-14684.
The second case we don't have on the docket, but I'm glad to discuss it with you.
Okay, I believe there's an agreed judgment
Oh, there, on which one?
on Eagle Rock.
Yeah, that's on. So if you have an agreed judgment, you don't need to worry about the continuance. So let's deal with Pratt first. It's first on the docket. So I know that you guys have probably heard my speech about this. For non-jury cases, we're very concerned about, usually I'm pretty flexible with DCAD. You guys, I'll give you quite a bit of time to get these things resolved. My concern is next year, it doesn't look like we're we may not have any non-jury weeks. And so I'm not sure when I could reset this. I'm glad to move your case, but how much time do you need?
We're
I think,
okay with deferring to plaintiff, whatever you think.
yes, Your Honor, I think that 90 days would be more than sufficient to continue this case, just to allow us a little more time to engage in discovery and try to get this case settled before the expensive trial.
So you've got two choices here, and let me explain why I'm giving you these two choices. So as you probably heard, the moratorium on jury trials has been extended to October. And so I'm trying to get everything worked out I can before then. So I could either set you on September 29th or December 29th, because I know that December 29th is going to be a non-jury week. That may be our last one for quite a while. So I don't know. Neither of them I know are ideal. I guess I could also set you on October 6th because that's a non-jury week as well. So October 6th or December 29th or September 29th.
I'm fine with either the October date or the December date. I think that would allow us plenty of time.
Which December 29th is, obviously there's vacation. I don't want to mess up anyone's vacation plans.
October works fine.
October 6th. Ms. Cox?
That's fine for defendant as well.
Let me go ahead then and.
Yes, Your Honor.
Oh, wait, somebody just entered here. Let me see what they're here for. I want to make sure they're not on your case. All right, somebody just entered with a phone number by phone. Who's on the call for that? Who's on the line on a phone?
Hi, Judge. Sorry, I was muted. This is Aaron Burke. How are you this morning?
Good. How are you?
Good, good.
So you're here on the Harris case as well?
Yes, Your Honor. I'm here for the SB defendant.
Okay. Can you check if they're here for a wedding? I'll do the scheduled wedding at 10:30, but I'm not doing just generally doing weddings. I'm just doing the one at 10:30. Megan, do you mind asking Rhonda what's the name of the people who are doing the wedding at 10:30? Okay, so you guys are hearing a motion for continuance.
Yes, Your Honor, for the Brandy Harris versus SB premium case.
Yeah, so you guys are set on September 15th. It's a jury trial, so I'll tell you the same speech I give everyone else, which is I have no idea when we're actually going to have jury trials again, but hopefully at some point we will. And when do you guys want to reset this to?
I think we had spoken about maybe February 2021. Is that right? Natalie and Aaron?
Yes.
Yes, that was the date in the suggested order. Although, Judge, I'm not sure that y'all will be trying jury trials even by then, but we're willing to risk it, and we can come back to you.
So I will say this: January. So what day are you looking at? February? Which day in February?
I don't know that we had a date. Natalie and Aaron, correct me if I'm wrong. I think you guys talked to Rob, but I didn't hear a
So
I don't think we had a specific date from the court yet.
So we currently have on February 2nd, we have 19 cases. February 9th, we have 19 cases. February 16th, we have a special setting and 10 more cases. And then on the 23rd, we have 12 cases. So, I mean, so the name is Justin Rayleigh is the people we're supposed to do the wedding for. Is that them or somebody?
Yes, they're the scheduled wedding.
Okay, they are. Good. Okay, so I don't mind setting you that week. I don't that month, but I doubt you'll go, but I'm flexible, whatever you guys want to do. Or we can move you later.
What do you want to do, Natalie and Aaron?
I would suggest we go ahead and just pick a date in February, and then we can reassess once we get closer to it. If we're going to mediate and do expert depositions, and we can reassess when we get closer to February.
Fine
That
with
sounds
me.
fine for us.
Aaron, you okay
for
with that?
SB premium. That sounds fine for SB premium.
You might be on mute, Aaron.
Oh,
I could hear him. Hey.
okay. I said that sounds fine. It says that I was unmuted, so I'm not sure. Can y'all hear me now?
I could hear you. I could hear you. It was
okay. Okay.
So what date did you all want to do in February?
I can do any.
Did you say the 22nd? The 22nd, is that the one you said had 12 settings, or was that the special setting?
That was, yeah, I think you're right. The last Tuesday in February, whatever that was, the 22nd or the 23rd.
And Judge, did you say that was the day that you had a special setting, or was
No,
it
it was the week before.
Okay.
I mean, February 23rd probably makes the most sense.
Right. I think so because of the number that you gave us. Judge, may I ask?
Sure.
Real quick, what have you all come down with any decisions on whether you're going to do jury trials by Zoom if the defendants are not agreeing to a 6-person jury yet? And I don't want to put you on the spot if that still hasn't been decided, but I know that there were some discussions of that.
Nothing's been decided on that, to be
Okay.
honest. But I am proposing to people. Oh, is this way to? Okay. All right. That's it. All right. I've been suggesting on now. What kind of case is this? Is this isn't a small car wreck, is it?
No, it's a
products
liability death case, Judge.
Yeah, I can't imagine that I would do that via Zoom unless things
Right.
unless we're in this another year or something.
Right.
But we're looking at for small car wreck cases to possibly, try to do my proposal. And this has not been, nothing has been decided, is that we try to do some of those via Zoom. Because I don't know what you've heard. If you've heard what Travis County is doing, they're going to be doing 2 jury trials a week for the whole county, not just for one court, starting in October. And so I've suggested, like, hey, if Travis County can do it, we're surely would be able to do it because we're far cooler than they are. But I shouldn't have said that on Zoom. But anyway, but so that's been my suggestion. Nothing has been decided. I think if we're still not able to do live trials by January, I'm going to be pushing pretty hard to say, look, we need to start doing Zoom trials. But I can't imagine on a case of this magnitude that by February I'd be ready to try a case like this.
Right.
But what do y'all think?
I agree. And then I also think, Your Honor, just candidly, and I don't want to speak for all the defendants, but I don't think that the defendants will agree to a 6-person jury. So, and I don't know how that would work out anyways, and don't really think I need to, speak on it further. But I think, why don't we do this? Let's go ahead, and if it's okay with you, Judge, let's just set it for the 23rd of February. That'll at least give us a date, and we'll schedule our experts and mediation, et cetera, from that date. And then, it looks like I'm reading the writing on the walls that we won't be trying a case in that time frame. We can come back to you, and hopefully things will, be a little bit clearer about which way we're going in Dallas, at least as far as jury trials go.
I want to make it clear. Yeah, I have no problem with that. Nothing has been decided. Nothing is
Right, exactly.
So,
exactly.
But I feel pretty strongly that we need to do something.
Right, I agree.
If we knew no one wants to do Zoom trials, I would vastly prefer to do in-person trials. But
right.
Can we go a year with no jury trials? I don't know that we can, but we'll see.
And it is the idea with the Zoom trial that the attorneys and witnesses would be at the courthouse, but the jurors would be by Zoom? Is that the idea, or would it be everyone on Zoom?
I don't think that's been decided. I think you could do it where everyone's on Zoom. We're pretty strict on limiting the number of people that are in the courtroom. I'm actually having the first live proceeding today. We're having, because we have a witness who's been testifying who has a very strong accent, and I just can't understand them over Zoom, and so they're coming in for a bench trial. But generally, I think you could do it by Zoom, but again, nothing's been decided. So we're on a very preliminary. I think we kept thinking that eventually this would all get worked out, but it just hasn't. So, all right. Well, guys, great to see you. We've reset this, and we'll just kind of hope everything gets better.
Thank you. Everybody stay safe.
Stay safe, guys. Bye-bye.
Thank you, Your Honor. Bye.
All right, Ms. Cox, are you still here? Are you here for the 10:30 or what? I'm not sure why you're still here.
I don't think that I actually have anything set for 10:30. So, Your Honor, may I be dismissed?
Oh, sure. Yeah, absolutely.
Okay. Thank you. Have a good day.
You too. All right. So we have the Thong Savat case. Are both sides here on that? I'm not sure, Ms. Hoffman, what you're here for.
I'm here on the urban loss matter, the one that you just called. I'm co-counsel with Mr. Slates.
With Thong Savat?
No, with urban loss. I entered a notice of appearance. I think it was about a week and a half ago.
I'm not sure. Or is that Brandy Harris versus SB Premium?
No, the D Thong Savat versus Urban Lofts Bennett.
Oh, okay. Okay. Yeah. All right. Thong Savat. Okay. So you're here on that case?
Yes, Your Honor.
Is everyone here on that case that needs to be here, or are we waiting on anyone?
Carl's here, but I think he's muted.
Yeah, Mr. Adams. Is there another attorney? There's a Mr. McHugh and Mr. Slates. Are they here?
I don't see Mr. Slates. He's my co-counsel. But I know he's aware of it because he's the one that sent me the link this morning.
So let me just tell you my schedule. Either I can hear this now, or I'm going to do a wedding. I don't do these very often anymore. So, but it's up to y'all. What do y'all want to do? Do you want to handle this now, or do you need to wait for your co-counsel?
I think we can handle it now. I mean, it's an agreed motion. Carl, if you want to unmute yourself. Carl, can you unmute yourself? Carl, you're still muted.
Okay, is that better?
There we go.
Okay. High tech. I don't know any reason why, unless you think Lawyer Slates would be jealous that we couldn't move forward. It's an agreed motion, and he's signed the motion along with me earlier in the week. So, and of course, the problem is no jury trials until there's jury trials. And he has suggested not resetting it before the first of the year. And in January, he's got 2 settings. So the first available week, provided it's a jury week, that we can both be available would be the first week of February. We haven't checked with the coordinator to see if that's a jury week yet, but we can certainly do that if the court will give us the chance.
First off, let me just deal with one issue, which is when did y'all pay a jury fee? Because it's currently according to the docket, it's on the non-jury docket. But you say in your motion for continuance that it should be on the jury docket. I just wasn't sure when you paid the jury fee.
We paid the jury fee before the case was continued on May the 12th. I'm not at my office, so I can't tell you exactly the date it was paid, but I know it was paid probably in April sometime. And I can, yes.
Who paid it?
The plaintiffs paid it. My office paid it.
Rhonda, can you tell if the jury fee's been paid? I can't tell here. Let me see. I can't tell that I'm not disagreeing with you, Mr. Adams, but I don't see that it has been paid.
Well, I'll be at my office later this afternoon, and I can double check and send the court an email or something to nail down the specifics.
Rhonda, can you check to see if it's been paid? It has been paid. Okay, I couldn't tell on my system, but it has been paid. So, you know, I don't know if I guess you guys weren't on the phone. And Mr. Slates is here now. Okay. And I think I saw somebody else just join us. Someone else just join us? No, I guess not. Okay.
There he is.
Slates. Mr. Slates, we were just discussing when we wanted to reset this to, and I heard that you guys are interested in maybe sometime in February. Let me just kind of tell you our current number of cases that are set, and this is going to change, I'm sure, but so February 2nd, we have 19 cases set. The 9th, we have 19 cases set. The 16th, we have a special setting in 10 cases. And on the 23rd, we have 13 cases set. So I don't mind. I don't have an opinion really as to when we reset it. I just want to give you kind of the information.
Well, I would expect that with all the backlog and so forth, virtually every jury docket for the foreseeable, as soon as it fires back up, it's probably everybody's going to be on it. We may have some of the largest jury dockets that the court's seen in a while.
Oh yeah, we're going to be digging out of this for years. One thing I would suggest to you guys is discuss doing a 6-person jury. I anticipate, though this keeps changing, that we'll go through a period where eventually we'll be able to do social distancing in trial, though that doesn't seem like it's going to happen anytime soon. And then we'll go back to
the 6-member jury panel. Sounds like a smart idea.
Mr. Slates or Ms. Hoffman?
Yeah, I mean, I'm open to whatever tools we can use to facilitate resolution. I would obviously want to consult with my client before I committed to that, but I've got no problem with it.
Is the 1st of February still a good date for you, John?
Yes. Well, I guess would it be the 2nd, it sounded like?
2nd of February.
Yeah, I'm sorry, 2nd of February. That's a jury week for the court. Is that correct, Judge?
Theoretically, yeah. What we're
On the books.
discussing, just so you kind of know, is that, and I think this is what's going to happen. I don't say Judge Hoffman said this is a definite, but I think what's going to happen is we're not going to have any non-jury weeks next year, just to try to catch up. So I don't foresee, and I'm going to strongly push for that, because we're going to be so far behind on jury trials that we just need to try just one after another, after another, after another, after another, after another. So if you could agree to a 6-person jury, and what people are usually doing is they're saying we agree to a 6-person jury contingent on that we still need social distancing. So if, like, say we have a vaccine and this is all passed, you don't need to do that. Anyway, so do you want to just do February 2nd, and then you guys can let me know if you'll do a 6-person jury?
Yeah, we'll talk about it and put it in the order if you've got.
Just send me a Rule 11 if you guys can agree to that.
About the 6-person jury?
About the 6-person jury. I'll go ahead and move the trial setting right now. Actually, you guys did not submit it. Oh, yeah, you did. Okay. Well, no, you didn't. You didn't submit an order with your, so we'll just send out a new trial notice. Rhonda, go ahead and prepare a trial notice on this for February 2nd, 2021.
And we'll talk about it and get that 6-person jury letter on file if John and I, after he checks with his client, I guess I should check with mine as well, but we'll get that on file too.
Thank you, guys. You be safe, okay?
Thank you, Your Honor.
Judge.
All right, bye-bye.
Bye-bye.
Okay, so can you tell them that we have to do the wedding right now? If you could just make sure you put on your mask. We don't, I can't, because